Our first witness this morning, our first witnesses, Andrea Bonina and Pery Krinsky, New York State Academy of Trial Lawyers.
Good morning. On behalf of the Academy of Trial Lawyers, I'd like to thank the Commission for giving us the opportunity to express our views on the important issue of attorney discipline in New York. My name is Andrea Bonina, and I'm both a longtime Academy member and a member of the Grievance Committee of the 2nd, 11th, and 13th Judicial Districts. I want to state at the outset that my testimony today does not reflect any point of view of the Grievance Committee, and rather is being given solely on behalf of the New York State Academy of Trial Lawyers.
Members of the committee, my name is Pery Krinsky, and I too am a longtime Academy member. My practice specifically focuses on attorney, judicial, and law school disciplinary matters, and I also serve as the chair of the Committee on Professional Discipline for the New York County Lawyers Association. But again, my comments too are limited to those with respect to the Academy. We're here for very important issues, and we understand that issues that deserve serious and thoughtful consideration. We all understand that the goal of the disciplinary process is not punishment, but rather the protection of the public. With that said, for a number of different reasons, it is the Academy's position that the issue of escrow theft by attorneys should not be the driving force behind any of the findings by this commission. The grievance and disciplinary committees throughout the state of New York receive approximately 10,000 disciplinary complaints each and every year. And yet, only a tiny fraction of those 10,000 plus disciplinary complaints relate to escrow theft. Conceitedly, the act of escrow theft is by far perhaps the most serious offense to be committed by an attorney. Lawyers themselves in this regard, though, play an important role in self-policing the profession. We understand that escrow theft, because it is perhaps the most serious, very often warrants disbarment or warrants a very serious and significant period of suspension. But again, this issue can be combated in other ways. We understand that not only are we a self-policing profession, but there are also safeguards set up in place, for example, self-reporting with respect to bounce checks. And the idea that under Part 1300, bounce check reporting rules actually create an internal audit procedure, in a sense, that again go to the issue of how escrow theft is very often determined or uncovered. While it is true at times that the appellate division may decide to impose prolonged periods of suspension where an attorney has stolen escrow or fiduciary funds rather than disbarring an attorney, that decision typically is the result of a well-thought-out analysis taking into account by the court issues of aggravating and mitigating factors. And indeed, disbarment still remains the default sanction in New York for escrow theft. Given this, respectfully, it makes little sense to reconstruct, or in a sense to revamp, the entire state's disciplinary system based on this one issue alone. Accordingly, the Academy respectfully submits that the matter of attorney escrow theft should not drive the findings of this committee.
With regard to the claims that New York's departmental-based system leads to statewide disparities in sanctions, it is our opinion that any disparities are reflective of the fact that each case is unique and receives consideration of all mitigating and aggravating factors. The fact that two lawyers who are found to have engaged in similar attorney misconduct may, in some instances, receive a different sanction is a result, in our opinion, to be applauded, not criticized. The Academy opposes any plan that would implement mechanistic and uniformity-driven rules such as those embodied in the United States federal sentencing guidelines. These guidelines, as I'm sure everyone recalls, were so widely criticized that the United States Supreme Court struck down their mandatory nature. Like criminal cases, each attorney discipline case is separate, and sanctions should take into consideration all of the contributions an attorney has made throughout the course of their career, as well as all mitigating and aggravating factors. That's the system as it exists in all 4 judicial departments today, and that system works well. There may appear to be unexplainable differences in the level of sanctions imposed in different cases, but largely that is due to the fact that certain departments include greater factual discussions in their disciplinary decisions. As with every area of law, each fact pattern in a disciplinary complaint is unique, and the fact that each fact pattern is unique will unavoidably result in individualized decisions. Any concern regarding disparities in decisions can be addressed by better education of the bar and of the public concerning the mitigating factors and the extent of the investigation.
The Academy does not believe that the procedural uniformity among the 4 appellate divisions is the key to a better disciplinary system in New York. Those who argue that New York needs a better disciplinary system and that the only way to attain that better system is through uniformity have in effect sought to lump together a number of different issues into a single basket in an attempt to argue that really a better system is a one-size-fits-all disciplinary process. Many of these concerns center around issues of delay, plea bargaining, and dissatisfaction by some with respect to the private nature of the attorney disciplinary process. With regard to the issue of delay, for example, disciplinary cases do in fact take a considerable amount of time, and that's necessarily so when we consider issues and safeguards such as due process and other protections afforded not only to lawyers but also to the public. Similarly, the issue or the principal issue of timing is really grounded not in the issue of creating a better system or a different system, but rather improving upon the system that we currently have, first and foremost, as we all know, by making sure that the necessary funds are in place to provide the disciplinary and grievance committees with the necessary resources to work within the system and to improve upon it. Somewhat related to this issue of delay is the claim that plea bargaining would enhance the disciplinary process. But simply engaging in plea bargaining, in a sense giving an attorney an opportunity to simply pick or choose or to identify which disposition he or she is interested in, would not negate the fact that a staff member of the disciplinary committee or the grievance committee would still nonetheless be required to fully investigate that matter regardless of any plea bargaining. Even with minor disciplinary infractions, when a grievance or disciplinary committee staff member investigates a case and chooses to proceed one way or another, whether it be informal discipline, private discipline, or public charges ultimately, or charges that are ultimately prosecuted, nonetheless, that staff member is required to fully investigate every and all matters. Indeed, the fact is that when it comes to disciplinary matters, whether they proceed on a formal or an informal basis, committee members always must take into account issues of mitigating and aggravating factors, therefore leaving certain at least disciplinary cases really not to issues of liability, but rather to mitigation and aggravation, which goes to the issue of sanction and not liability.
There's some that would argue that the attorney disciplinary process should be open to the public at the charging stage. The Academy is firm in its view that an attorney's name and reputation should not be damaged or ruined unless or until an appellate division has made a determination that a serious misconduct has been committed. A complaint against an attorney is which is not proven, is just that. It's an unsubstantiated claim. To allow an attorney's reputation to be sullied based on an unsubstantiated claim would simply be wrong. Everyone is innocent until proven guilty. Where there's theft of client or third-party funds or other criminal conduct by an attorney, which is clearly the type of conduct that most impacts the public, law enforcement is often advised at an early point in time, and the attorney is prosecuted promptly. In those instances, it would make no difference if the disciplinary process were opened at the charging stage, because by that point, the public has become aware of the attorney's arrest. Finally, uniformity of process and standards among the 4 appellate divisions is not necessarily a worthy goal in and of itself. In New York State, there is legislative and judicial recognition that each appellate division should control the disciplinary process and the disciplinary standards within its own borders. Most disciplinary complaints do not deal with black and white issues. Most complaints deal with more subtle issues than black and white issues such as theft or theft of client or fiduciary funds. They deal with issues such as conflict of interest, client neglect, client inattention. And the resolution of those types of disciplinary complaints is driven very much by the standard of practice of lawyers in each judicial department. There is a genuine benefit to local control of disciplinary conduct, and that can only be accomplished by a disciplinary process which considers local community standards. The Academy asks that this commission exercise its wisdom carefully and recognize that fundamentally the New York State Attorney disciplinary system works and works well. What the disciplinary system requires most is a financial commitment to provide greater resources, both for increased staffing and for better attorney education.
Excuse me, I'm going to interrupt you because your time is up, so if you could just summarize.
My final sentence is that greater resources and not procedural fixes will improve the system and make it an even better one.
Thank you. Members of the commission.
Thank you. Thank you for your testimony, and I've read the Academy's submission. And I have a question for you on this issue of uniformity. We've heard from you, and the suggestion has been from others as well, that the disparity in severity of punishments in different departments is, as you say, a factor of individual attention to individual cases. But it seems to me, if that were true, what we would see, for example, in one department, a range of punishments, and another department, a range of punishments, and they would look similar. But what we're seeing is a cluster, that in one department there's a cluster of severity with respect to a number of offenses, and with respect to the same offenses in another department, much less or less severe punishment. So it would seem to me that that difference cannot be accounted for by individual attention to individual cases, because that would occur in both departments. Any thought on that?
Well, I do believe that when we have grievance complaints that are under review, there is a very significant investigation. Each case is taken individually. There are always mitigating factors that are considered, and that's something that I believe is something to be applauded. I think that's something that it has a value because each case is different, and there are cases where the substance of the complaint may be the same, but one practitioner, there's evidence that they did not work with the committee, that they weren't responsive, and that may lead to a more harsh penalty, where somebody could come in with mitigating evidence, such as that they were suffering from depression or mental illness, and that could lead to a less severe penalty.
Yes.
Thank you for your testimony. One of the things you mentioned is that there are benefits to local control over the disciplinary system. Could you please elaborate on that for us?
Sure. I think one of the things, and going back to your question as well, and it dovetails, is, for example, when we consider, for example, that the second department accounts for approximately 20 to 25% of all attorneys in the state of New York. Yet, the second department also accounts for approximately 59% of all escrow thefts. The numbers, in a sense, don't match. And it's a prime example, really, of why there are certain problems that exist with respect to attorney conduct in certain departments or in certain geographical locations, but not in other departments or other areas. And it's for that very reason that the individualized attention, the individualized justice, in a sense, that's afforded to lawyers on a local level is necessary, because it allows discipline and grievance committees, and in turn the court, to take into account the very specific issues that exist facing lawyers within that geographic area.
And this is not something that's unique to the grievance process. If you were to review values of different injuries, let's say in a personal injury case, the value of a broken leg in the Bronx would be quite different to the value of a broken leg in Erie County. There are differences based on local thoughts and local practices and local ideas that do change from department to department.
Yes.
Thank you, Ms. Bonina. Mr. Krinsky, appreciate you taking the time to come down. On this point, on the disparity issue, and I understand the argument that what's perceived as disparity is really in the details of the litigation of the facts. But when you have a system where it's known and those of you that yourself, Mr. Krinsky, who practice in this field, when you advise your client respondents or client lawyers, it's pretty well understood. If you commit an escrow theft, an intentional escrow theft in the first department, they virtually begin with a presumption of we work from this disbarment, and then we go from there if there's sufficient mitigating circumstances. That's not necessarily the case elsewhere around the department. So whether you're stealing escrow funds in Erie County or on Long Island, it's the same act of misconduct. And when you have a process that the jumping off point is different, would you agree that there's a measure of fairness in that not only to the lawyer, the accused lawyer, but also to the victims and those clients as to whether or not everyone's going to be treated, at least from the jumping off point, starting the same? And the corollary to that is, if that's the case, why is it problematic for the courts to adopt a set of guidelines or standards for sanctions as the jumping off point that's done in the majority of the states?
I think twofold. One, with respect to the beginning point or the ending point, I think it's perhaps even somewhere in between. I think we understand that perhaps very often there's a floor and there's a ceiling, and a degree of discipline fits within that range based upon a set of factors, such as aggravating and mitigating factors. As to, in reverse for a moment, the idea of creating a standardized set of guidelines in and of itself is not problematic, but I would also suggest that, in effect, we already have those guidelines in place through decisions that the four appellate divisions have issued, identifying very specifically aggravating and mitigating factors, no different than those cited by at least 3 out of the 4 appellate divisions when citing to the ABA standards on the imposition of discipline, both aggravating and mitigating factors. So we've already, in effect, taken those into consideration. But what I think really goes to the heart of this issue is that the individualized justice, if you will, and imposition of discipline on lawyers really must be aimed at identifying what the issue is, why it came about in the first place, how we ensure it never happens again. And when we consider all of those in the context of the need for greater education for lawyers, we understand why there's perhaps disparity, because different lawyers require different degrees of sanction and education to ensure that discipline or that misconduct doesn't occur in the future.
Justice Gibbons.
Yes, good morning. I have 2 questions. The first one I think is maybe can be dealt with in almost a yes or no answer. And the first, so that question is, what is the Academy's position on public disclosure in the instance where there has been an interim suspension? Would you be against that, or would you be for that?
It's the Academy's position that the current status of the law, Judiciary Law 90, is properly in place, which says that unless and until public discipline is imposed, the matter should not become a matter of public record, because we understand that even though an interim suspension may have been imposed, there has not yet been a full adjudication as to that lawyer's guilt or innocence. And until that happens...
There's a very high standard of proof to be met for the purposes before there's going to be an interim suspension, correct?
The high standard of proof, the answer is yes, but that high standard of proof is put into place specifically to, in a sense, take a lawyer and to sideline that lawyer until such time that we can make a full determination as to the full scope of what is happening, including issues of guilt or innocence.
The second question relates to the question of efficiency, and as a practitioner, I'm addressing you in particular, Mr. Krinsky, and that is, where do you see the cause for delay other than in the question of funding/staffing?
I think it's a combination perhaps of, one, lawyers not being represented by counsel or not having a resource to go to better understand the disciplinary process. And I think, unfortunately, some lawyers who find themselves facing a disciplinary complaint don't understand the distinction between perhaps a disciplinary complaint and a civil complaint. the idea that it's not simply about admit, deny, but rather it's about letting the committee understand a story, telling a story, so that they understand either something was done properly here or wasn't done properly here. But I think that there's a lack of understanding in and of itself within the disciplinary process itself.
So then, as all lawyers are required to attend an ethics program, you suggest that all lawyers be required to attend an ethics program that effectively goes through the process, so that no lawyer can say that he or she didn't understand the significance of the receipt of a complaint and what needed to be done.
I think that that's part of it, sure, but if someone is taking that CLE at the beginning of their career, as is often the case in the beginning interview CLE programs that are offered, orientation, thank you, at the orientation programs, very often it's not until, unfortunately, or better or for worse, it's not until perhaps 10 years into your career where you're actually faced with that disciplinary complaint. And why aren't we re-educating lawyers at that point? And at the same time, why aren't we educating complainants about the proper use of the disciplinary process versus the improper use of the disciplinary process?
Thank you both for your testimony.